Krokidas and Bluestein. Firm has represented charter schools since the first charter schools were formed in 1995. We're also honored to represent the Mass Charter Public School Association, our co-host for this morning's webinar. Krokidas and Bluestein, we have a full-service employment law practice. We deal with wage and hour issues such as overtime, as well as some of the other hot issues in the wage and hour area, including misclassification of employees as independent contractors, issues of off-the-clock work, compliance with meal break regulations, minimum wage, issues under the new earned sick leave law. We also had a number of questions from charter school and other clients over the past couple of years regarding the proper use of volunteers and interns. We deal with FMLA, or family and medical leave issues, discrimination questions, questions of harassment, whether it's sexual harassment or other forms, accommodations on the basis of disability. Deal as well with whistleblower claims. We've seen a number of these where teachers or others claim that they've been disciplined or terminated for opposing unlawful practices or policies. We deal with discipline decisions, counseling human resources or managers on decisions about when to impose progressive discipline and how best to structure that discipline, decisions about termination, severance agreements, as well as drafting and updating employee handbooks. Do investigations of complaints of all kinds, whether they're harassment, discrimination, or others. We do compliance audits, and we also do a number of trainings sessions, both online and in person, for supervisors regarding wage and hour compliance, issues around progressive discipline, and prevention of harassment. Those are some of the areas, and if you have questions about any of these at the end, we're happy to discuss those as well. The couple of quick notes before we get started about the webinar process. The end of the presentation, we're going to post the slides as well as a recording of the session on the Krokidas and Bluestein website. You're welcome to refer to that and to share it. If you have questions at any point during this morning's presentation, you can type them into that questions box on your screen. We'll have plenty of time for Q&A at the end of the presentation. That's when we'll plan to address those questions. Your questions are not visible to the other participants, just to me on this end, so feel free to pose any questions that you'd like. In summary, our goal this morning is to give you an overview of the current law regarding overtime, the obligations of employers, particular emphasis on these new regulations, and on the issue from the perspective of charter schools, including the options available to you to ensure compliance with the Department of Labor's new regulations. So, I want to start with a little background and some basics which most of you are familiar with. The Federal Fair Labor Standards Act, the FLSA, is the key statute here, the key law, requires that most employees be paid at least the federal minimum wage, or in Massachusetts, state minimum wage, which we know is higher, for each hour that's worked, as well as overtime pay. Overtime pay is not just a matter of paying for the time that people work beyond their scheduled hours or beyond 40 hours, but the pay has to be what's called a premium rate, or time and a half. So for all hours worked over 40 in a work week, the basic requirement is that people be paid at a time and a half rate for that time. Now, while most employees are entitled to overtime, the statute does provide certain exemptions. And they fall into a number of categories, including administrative employees, professional employees, executives, highly compensated, what are called outside sales employees, computer professionals, as well as teachers specifically. So these employees are known as exempt employees. We use that term to mean that they are not eligible for overtime pay. You do not need to pay overtime to an employee who is exempt. But to be considered exempt, the employees have to satisfy a number of tests. We're going to focus on those, and particularly the job duties tests. We'll talk about this in a minute. I mentioned teachers being exempt specifically because our focus, as a result of that, our focus today from your perspective, I believe, is going to be largely on paraprofessionals, classroom aides, office staff, administrative staff, and positions of that sort. And we will talk some more about that. So let's talk about what the three tests are as the federal government has developed them. And I want to mention a common misconception as we go through these. So the first is the salary level test. And this is where the reason this has all been in the news recently is that the salary level has been increased for the first time in a long time by the Department of Labor through new regulations, which are going to take effect on December 1st. the level of salary that needs to be paid to an employee in order to meet this test to enable them to be exempt from overtime is $913 a week. You need to have that as a minimum salary in order to qualify for any of the three key exemptions, the executive, administrative, or professional. That's the salary level test. The second is the salary basis test. Generally, you need to be paying an employee in order for them to be exempt from overtime on a salary basis, meaning they get the same pay every week regardless of the quality of their work or the quantity of their work. The third, and the most important, is the duties test. And before I get to it, I'll mention the most common error that we see in talking to folks about these issues is that it is widely misunderstood to be the fact that if you pay an employee a salary, that is the end of the discussion, and that they are automatically, therefore, exempt from overtime. In fact, many human resources professionals or others looking at these issues use the terms exempt and salaried as synonyms. They're not, and they're not because of this third test. In addition to the salary level test and the salary basis test, each employee has to meet the duties test in order to be qualified to satisfy the exempt status. The primary duties have to meet certain very specific criteria, which have been parsed out and developed further by regulations and by opinion letters issued by the Department of Labor. And so we'll talk in some detail about those duties tests. The new regulation, as I said, raises the salary level requirement. It's been $455 a week, about $23,000 a year, to $913 a week, $47,476 a year as the minimum salary level if you're going to label somebody as exempt from overtime. The slide describes how they calculated this. Based on the 40th percentile of weekly earnings. Not as important to you as the figure itself. $455 a week is the old one, $913 a week is the current as of December 1st. The regulations also raise the salary level requirement for a different exemption, which is exemption for what are called highly compensated employees, up from $100,000 per year, which it's been, to $134,000. That's the 90th percentile. There are going to be a number of options for you in looking at employees who might be affected by these changes. And the first thing I want to point out is the timing of when you want to make those changes. The December 1st is a Thursday, probably the worst time possible to make a new law effective because that's a disaster and a headache for anybody who's running payroll to try to make a shift in the middle of the week. So the suggestion that we've made to others is that you consider doing it the week before. That's Thanksgiving week. It offers a couple of advantages. Gives you a chance to do a dry run. It's also a week in which it's very unlikely that anybody's actually going to work overtime because they'll be working at most 4 days that week, and most people will actually be working just 3. These threshold figures are going to be updated every 3 years automatically. The department will publish those, so it's going to be important for you to calendar for end of 2019 to think about the next update, which will take effect January 1st of 2020. The most likely figure there will be up to 984 on a weekly basis, or 51,000 at that time, and an equivalent increase for the highly compensated employee threshold. One of the things to consider in deciding whether you've established that one of your employees meets this threshold is what you can count as salary. And the regulations are quite specific that to the extent that commissions, which wouldn't be relevant to you, are paid, those can be counted. Non-discretionary bonuses, bonuses that are paid automatically as opposed to at the discretion of a manager, can also be counted. Incentive pay of any kind to which the employee is entitled can also be counted toward the minimum threshold. I mentioned the regulations will take effect December 1st. If you're going to make an upward salary adjustment, if you're going to increase somebody's compensation to try to satisfy that salary level test, you're going to need to make that happen before December 1st. Again, the reason to do it the week before to ensure that employees continue to be considered exempt from overtime. Keep in mind that many employees are paid on a biweekly basis, so you're going to need to look at it on a basis of the pay period and make sure that the adjustment is in place for that pay period that includes that magic date of December 1st. So what are some options that you have to address this new threshold, the change that's coming December 1st? One is simply to pay the employees who are now considered non-exempt, therefore eligible for overtime because they don't meet the salary threshold. In other words, you've got somebody who, under the old test, was making $23,000 a year, but they don't make $47,000 a year. That renders them, if you don't make any changes, automatically eligible for overtime. First thing you could do with such an employee is to pay them time and a half for any overtime hours that they work. Second would be to raise that person's salary above the threshold. Here's the key point, though. Many employers think, well, that's all I need to do. I'll raise the salary. That renders that person ineligible for overtime. It ensures that they are exempt. The difficulty is that that decision has to be made in conjunction with a serious review of what their duties are. It's not only a salary gap here that needs to be made up, there's often a duties gap. Because of the misconception I mentioned earlier, where many employers have been operating under the assumption that having a salary at a certain level is all they needed in order to qualify employees as exempt. There is a duties gap in many instances. And case by case, position by position, review needs to be undertaken to be sure that the employee meets the duties test as well as the salary test. And this is particularly important because, as we'll discuss, there's going to be a lot of attention to overtime compliance in December, coming up on December 1st, as there'll be press attention. Certainly lawyers are paying attention to this issue, and employees will therefore be focused on their rights under the Fair Labor Standards Act and Massachusetts laws. So the duties gap is one to assess, as well as the salary gap. Another option is to say we're not going to need to pay overtime because we're going to limit the employee to 40 hours a week. It's an option. You need to keep in mind, however, that if the employee is permitted to, or you would have reason to know, should know, that they are actually working more than 40, even though you've declared that they're a 40-hour-a-week employee or instructed them to work only 40 hours a week, you're going to need to pay for that overtime. If it happens, here's the suggestion that we routinely give, which is you need to treat it as a disciplinary matter. If somebody is instructed not to work overtime without prior written permission of a supervisor and they don't follow that rule, they can be disciplined for it. You need to pay them for the time they work, but you can treat it as a disciplinary matter and enforce the rule. So that's one option. Limit the employee's hours to 40 hours. Another is to think about the cohort of employees in this scenario. Who are their colleagues? Who does the work, similar work with them? Are their duties part of their workload that can be redistributed to minimize the need for overtime by any particular employee? I mentioned Massachusetts law in addition to this federal law, which is getting all the attention because Massachusetts follows the federal law, but imposes particularly stringent and tough punishments on employers who violate wage and hour laws. And for that reason, Massachusetts, it's worth pausing to think about the significant differences and the reasons to focus on compliance if you're an employer in Massachusetts. Unlike the federal law, in Massachusetts, if you are found to have violated any of the wage and hour laws, including overtime, the damages will automatically be triple the amount of pay that's owed. So think about that. If you have an employee who's owed time and a half for 2 hours of work in a week, they're going to automatically, regardless of whether you intended to not pay them, it was an oversight, doesn't matter. There's no requirement that they show this was a willful violation or deliberate. Automatically, they're going to get 3 times the time and a half wages that they're owed. In addition, employee will recover their own plaintiff's attorney's fees if they prevail in a wage and hour lawsuit. So in addition to paying your lawyer, if you lose one of these cases, you will be required to pay the reasonable fees incurred by the plaintiff and the plaintiff's lawyer. Another significant factor, and this is particularly an issue in Massachusetts, but applies federally as well, is the potential for these cases to be treated as what are called class actions. Wage and hour cases are often filed in the name of one or two individuals, but on behalf of an entire class or group of employees. If the court certifies such a class, agrees to expand the case from the named employees, who are called the class representatives, to the entire group of employees. So let's say all paraprofessionals at a school, all office staff, all individuals who've worked in a particular job category in the last 3 years, let's say. If the court approves such an expansion, those cases can rapidly add up in terms of the damages if you lose, and therefore the exposure. So, message is straightforward. To avoid all of these penalties and damages and remedies, you've got to ensure that you're in compliance. You're following the long-standing laws around the duties test, and as well as the new regulation on the salary level. As you're mostly aware, I assume schools as well as institutions of higher education are generally going to be covered by the minimum wage and overtime provisions. Teachers are not an issue here because they are exempt automatically if their primary duty is teaching, instructing, or lecturing. It's a list on the screen of the kinds of teachers who have been held to be automatically exempt. And when I say automatically exempt, it's important because it doesn't matter what the level of salary or earnings are. Teachers, like lawyers and doctors, are exempt from overtime regardless of their salary level. You can see by the list that there may be some issues at the margin, particularly if you're talking about a preschool teacher. One of the questions the Department of Labor looks at is, what's the primary duty? What's the main focus? Are we talking about caretaking, or are we talking about education? So there may be issues there, but for the most part, I think for you all in the charter school environment, you should assume that your teachers are exempt from the obligation to be paid overtime. So instead, we'll be talking, as I say, primarily about paraprofessionals, office staff, administrative staff. Okay, so we talked about the salary test, mentioned the duties test. Your employees' job duties have to primarily involve executive, administrative, or professional duties as defined by the regulations. Before we get to those, I'll mention again the highly compensated employee who can be exempt largely based on the salary. Anybody who's paid over $134,004 per year and who performs office work, meaning non-manual work, and who customarily performs one of the identified executive, administrative, or professional duties that we'll talk about in a minute. Just one of them is all they need. They're going to be considered exempt. So unlike some other categories, this is an easy one to satisfy: salary and one duty. Let's talk about where the real battles come, and that has to do with the administrative, professional, and executive exemptions. Start with the executive exemption. This is a list of requirements, all of which need to be met. So again, starting with the compensation, the salary level, $913 a week. Check that box. Next box that you need to check is that the employee's primary duty is that of somebody who is managing your operations, or a division or department within the school. It's to be a manager, not just labeled a manager. There are numerous cases out there, and we'll talk about some at the end of the presentation, where employers have said, this person's a manager. It says so right in their job title, therefore they're not eligible for overtime. Courts, the Department of Labor, and attorneys will look behind the labels. They will look at the actual job duties. They will look at the job description. So a label does not immunize you or protect you from having to pay overtime. It's the actual job duties. So primary duty must be managing. Second, for this exemption, that employee must regularly direct, supervise the work of at least 2 or more full-time employees, or the equivalent. So it could be 4 half-time employees. So they have to have people under their supervision, under their direction. One of the ways we measure whether they have people under their direction, is what their role is in hiring and firing decisions. They have to have the authority to hire or fire, or at a minimum, their recommendations on hiring and firing decisions or promotion have to be given particular weight. Those are the regulations. Each of these has been the subject of litigation in the courts, as well as opinion letters issued by the Department of Labor, interpreting them in the context of very specific jobs and factual scenarios. And these are the touch points that we use in evaluating whether a particular employee in a particular position does in fact qualify for this exemption and the other exemptions. Turning to the professional exemption. Again, you have to meet all of these requirements. The compensation level is the same, $900 a week. Here, the primary duty has to be the performance of work that requires advanced knowledge, work which is predominantly intellectual in character, and work that requires the consistent exercise of discretion and judgment. This work, knowledge, has to be in a field of science or learning, and it's a field in which specialized instruction, education is required, a prolonged course typically. So for this one, we're often looking at job descriptions and job postings to see what the minimum education requirements are. So this example that might be relevant to some of you has to do with social workers. There's a lot of battles about whether social workers are qualified for the professional exemption or not. And some of the guidance has to do with the level of education required for the position. Master's degree typically is going to be sufficient to satisfy this. However, if you have a job requirement that is less than a master's degree, bachelor's degree in certain fields may not be sufficient. There are lots of nuances on this, but I'll mention it just because that's one battleground is social workers. If you've got paraprofessionals for whom a bachelor's degree is the only requirement, it's unlikely they're going to meet this professional exemption. We can look at it on an individual basis, but this is really designed for specialized positions that require specialized training. Okay, the next category is what we call creative professionals. Not clear whether this would have applicability to you unless you've got web designers or somebody on your staff. Creative professional, again, meets the salary requirement, and then their duty, their primary duty, must be the performance of work that requires invention, imagination, originality, or talent. That's everybody, I assume, but here it's specific to a recognized field, that originality has to be in a recognized field of artistic or creative endeavor. So again, web designers might well fit this category. Not sure how many of those would show up in a school, but that's the fourth exemption that we've just mentioned to you. The last, which is more likely to have application, is the administrative exemption. To qualify for this, again, $913 a week, the primary duty has to be office or non-manual work that's directly related to the management of your school or your school's operations, or those of your customers, students in this instance. The primary duty language is critical because it's not whether they do any of this, but it has to be their primary duty. There's no set percentage, but there's a lot of guidance as to what primary means. The other element here, which is critical and is where employers often get tripped up, is in addition to the subject area of the work, the employee has to be, as part of their primary duty, exercising what's called discretion and independent judgment. That's an important threshold right there. They're not following a set template. They're not doing the same thing every day. They're not following very specific instructions from somebody else. They have discretion and independent judgment about how to do their job. But not only do they have to have that discretion and independent judgment, it has to be on matters of significance. So if somebody had independence and independent judgment and discretion to administer the petty cash account in your school's office, not going to be enough because that's not a matter of significance to the operation of the school. So we're talking here about office staff, directors of operations, folks who have high-level responsibilities and exercise discretion and judgment. Note that this category can be satisfied by someone who does not directly supervise others, but again, they must be at a level where they are exercising their own judgment, making decisions without micromanaging or templates or such from others. So that's the administrative exemption. Talked about the highly compensated employee exemption. Again, just one, if they meet any one of the duties we've been talking about for these other three categories, executive, administrative, professional, they make $134,004, they're going to be exempt under the highly compensated category. Some other categories that don't have any application to schools, such as outside sales staff and such, that we haven't included here. All right, so this slide is called cost-neutral salary formula, and it comes from a question that's come up which says, if I want to take an employee who is no longer exempt because they don't meet the new salary threshold, I know they're going to work some overtime, and I want to pay them a compensation package that is predictable, which is going to cover both their base pay and their overtime rate. Is there a way to do this? So just as a matter of mathematics, and some of you can maybe defer to your math teachers on this formula at the bottom of the screen, it is possible, and I want to just explain why it's possible. You can drop your base pay rate for the employee and allow him or her to make up that shortfall by receiving overtime. The question comes up, as I say, is what should that pay rate be, so that when the person works the overtime, their total compensation is going to be the same as it has been before this change. So the cost-neutral formula is possible if you have a good estimate of that person's expected weekly hours, including overtime. The formula is there. It's their weekly salary divided by the 40 hours plus the product of the overtime hours and the multiplier of 1.5. Now, I'll give you an example of how this would work. You've got somebody who you know is going to work 45 hours every week at a weekly salary of $800. The hourly pay rate for purposes of calculating overtime is $20 an hour, because you calculate the hourly rate based on the 40-hour work week, $20 an hour. Overtime rate is going to be time and a half, or $30 an hour. So if this person does, in fact, work as predicted 45 hours that week, they're going to make $950. $800 the base salary plus 30 times 5. If you went with a cost-neutral formula, it would work this way. Same 45 hours a week, but the base weekly pay rate is going to be dropped to $16.84 an hour instead of $20 an hour. Overtime rate would therefore be $25.26. If, in fact, they work the 45 hours, the weekly take-home pay is going to be the same $800, but it's going to be calculated as described on the screen. $16.84, the overtime, the base rate times 40 hours, plus the 5 hours of overtime at the overtime rate of $25.26. Key issue here is, unless your employee reliably works and is paid for those 5 hours of overtime every week, he or she is going to be earning less under a cost-neutral formula. They're not going to be pleased. It's going to lead to a fair number of questions. So this option may not be viable for many employees because you simply don't have the predictability of how much overtime is going to be worked. But I wanted to lay it out as a reference point for you nonetheless, because we do get this question. Employees who, if you do nothing and no longer meet the salary minimum, they're going to be reclassified. They're going to become what's called non-exempt for overtime. It doesn't matter whether they're paid on a salaried basis or an hourly basis. They're subject to the same wage and hour rules as any other non-exempt employee. You've got to maintain accurate time records, even if they never work any overtime. When I say accurate time records, I'm talking about contemporaneous records of the actual time worked on a daily basis, not a summary timesheet that they're asked to fill out at the end of the week and instructed to put in 40 hours no matter what they worked. Accurate, contemporaneous time records. That can be via time clock. It can be via paper timesheets. Doesn't matter. But they have to be accurate. In addition, like other overtime eligible employees, who we call non-exempt, you're going to need to keep an eye on their hours that they're actually working to learn when, in fact, you have to pay them overtime, when they are owed overtime. If they are working after they punch out or sign out, what's called off-the-clock work, that needs to be paid. So you need to monitor it. If people are signing out at 3 p.m. when the school bell rings but are staying afterwards to do paperwork or any other task, that work needs to be paid. And it needs to, if it exceeds 40, if those hours are above 40 hours on a weekly basis, they need to be paid at that overtime rate. Should mention a question that comes up a lot. It's not 8 hours a day. It doesn't matter if somebody works 9 hours on a particular day. It's the weekly total. The overtime obligation is triggered by 40 hours as a weekly total. There can be variation among the days in the week. Second area you need to look at and monitor are meal breaks. Massachusetts law, 6-hour shift, you're entitled to a 30-minute unpaid meal break. If employees are not leaving their stations and are working, answering the phones if they're a receptionist or an office worker, responding to requests for supplies or anything else from teachers during their meal breaks, they need to be paid for that. And again, if that puts them over the 40, they need to be paid an hour and a time and a half for that time. Travel time to work related seminars and trainings needs to be paid. The last one is a modern problem, and see it in a lot of settings, which is remote access is very easy these days via somebody's smartphone or their computer or laptop at home. Sign in, check a few things, answer some emails, work on a chart. That's work, regardless of where they're located. So if you're aware, or should be aware, that you have employees who are working in the evenings, mornings, on the train on the way to work, that work needs to be paid, and again, monitored to see whether it triggers the overtime pay rate. Okay. If you're going to increase the salary to meet the salary threshold for a particular employee to try to maintain their exempt status, here's a flow chart indicating some of the steps you might want to take. First thing, again, is to look at the duties and to see whether the primary duty is, in fact, an exempt one. If not, before you bother increasing the salary, you might want to make sure that you're meeting the duties test by perhaps shifting some duties around to be sure that they are, in fact, meeting the duties test. You want to look at the job description to be sure it aligns with the actual job duties. These are all things that are going to be looked at if there's a challenge. Might as well, I would add as well, you might look at the job posting that they responded to, as well as the actual job description, to make sure that they are all consistent and establish the exempt nature of the duties. You want to have a communication plan. You want to give them written notice that they're getting a salary increase. You want to have an explanation as to why. You want to make sure that the employees, managers who might get questions about this also understand how to answer those questions about why changes are being made to comply with the new federal overtime regulations. Also want to be sure that you make the change everywhere. That second box on the right talks about not only payroll, but wage statements and other places where salary rate needs to be accurately reflected. And again, it has to be in place before December 1st if you want to get the benefit of the change. Thing you're going to need to be thinking about as we get close to December 1st are potential claims and how to anticipate those when you're making decisions about how to address these changes, about whether to raise salaries, whether to reclassify people, whether to do a review of whether positions are in fact exempt. Here are some categories of claims that you might be seeing. We certainly will be seeing across the state after December 1st. You might have some exempt employees who say, well, my pay wasn't raised. I see that Jane Smith got a pay raise up to $913 a week. Mine was at $920 a week, and I didn't get a raise. Why not? Is that unfair? Is that give rise to a discrimination claim? That's one category. Second would be employees, exempt employees who have had their pay raised, but think nonetheless that they should be treated as non-exempt and therefore eligible for overtime. This is a large part of the category we've been talking about. You go through the effort to raise the salary, but then they come back and you say, well, thank you for the increase in salary. I agree, I meet the salary level test, but I have never met the duties test. I I'm not an administrative employee as defined by the regs. I'm not an executive employee, and therefore I believe I should be paid for overtime not only going forward, but 3 years back, which is the statute of limitations, the basic statute of limitations for wage and hour claims in Massachusetts. The third category would be reclassified employees, again, who question why they weren't classified as non-exempt or overtime eligible and paid overtime from the start of their employment. These changes, the press and the discussions around this are going to trigger these questions. Have I been properly classified historically? Why haven't I been paid for the hours I worked above 40 hours? Why wasn't I paid overtime? Finally, reclassified employees who say that they have worked off the clock, they've missed their meal breaks, or their overtime has been improperly calculated. These are all potential sources of claims, and in thinking about how to respond, which options to pursue in light of the new salary level test, you need to think about how to minimize the risk in all of these categories. Consensus is that there is a risk of a wave of these sorts of claims. Again, there's going to be press coverage about the effective date of the new rules. Employees, lawyers are going to be seeking avenues to pursue claims. More lawyers who have never litigated or handled wage and hour claims are going to be learning about this and thinking about whether to expand their practice areas and to bring claims under the Fair Labor Standards Act and the state law. Discussion within the work. Inevitable, right? I got a salary increase. You didn't. I hear there's some new rules. What's going on? How much do you make? How are you paid? Do you get overtime? Inevitable and perfectly lawful, by the way. It is illegal for an employer to say you can't discuss your compensation, and stems from a whole other area of law regarding rights to organize and to talk about workplace conditions. So, and do not even consider restricting those discussions as a topic, right? You can't say you can't discuss your salary. So those conversations are going to happen. We talk about reasonable restrictions on when non-work discussions can be held generally, but you certainly can't prohibit discussions or comparison of compensation. This slide quickly just shows a trend which might get your attention if none of the rest of these figures and examples I'm going to show you will. This is the increase historically in the number of Fair Labor Standards Act cases brought in the federal courts. It doesn't reflect state court filings. The trend is obviously upward, and it's pretty well predicted that in 2017 the number is going to be significantly higher. You may have read that because of these the new salary threshold, nationwide, 4.2 million employees are going to be eligible for overtime pay because they have not, who have not previously been eligible. So how that plays out in your individual schools, again, is going to require an assessment position by position. But it's a big change nationally. The jump is significant, and it picks up between the 23,000 and the 47,000 figure, as I say, nationwide, over 4 million workers. These cases have already been brought before these changes. Overtime is a hot area of litigation. Massachusetts, a blue-collar setting, a small case. There were just 13 employees who claimed that they were not paid overtime when they worked over 40 hours. They claimed that the people who were labeled managers and paid a salary, nonetheless, were improperly classified and should have been paid overtime. Also, some clerical staff. Settlement here was a mere $13,000 in unpaid overtime damage, about $1,000 per employee. Class actions, though, as I say, the numbers get a lot higher. You've heard of Bloomberg out of New York City. They had a class action brought on behalf of customer service employees. An example would be one of the plaintiffs who claimed that she worked 10 additional hours per week without pay. What was she doing? She said she was expected to come into work before punching in, before her shift started, that she would not leave the office until after her shift had concluded. So that's off-the-clock work on both ends of her shift. Claimed that she worked from home after leaving the office. She claimed that she worked through lunch. This was a case on behalf of thousands of employees, of at least hundreds of Bloomberg, and it was certified, or was likely to be certified, as a class action because the practices alleged were common, and a court was likely to see that these were similarly situated employees, therefore appropriate for a class action. Decision was made by Bloomberg's lawyers to settle the case. The figure was $3.2 million. Closer to home, last month, some construction firms were investigated by the Federal Department of Labor. 478 workers at issue. The department found violations, including a misclassification of most of their employees as independent contractors. This is a very hot issue. It's peripherally related to overtime. These are people who were doing the work of the construction firm but were paid as 1099 independent contractors. They were not paid overtime because they weren't considered employees at all, let alone exempt employees. And the Department of Labor concluded that one of the reasons they were treated that way was to avoid overtime wages as well as other benefits. There were some shenanigans around how they were paying as well, but a big part of this $2.4 million settlement was attributed to the failure to pay overtime for employees who were entitled to it, who should have been treated as non-exempt. Dollar General stores, discount retailer, same thing. They had people they labeled managers, but the testimony came out that they were generally spending less than 10 hours every week doing what were legitimately categorized as managerial duties. They were working as many as 90 hours a week. The complaint alleged that many of them were operating the cash register for many hours a week. Obviously not a managerial task. So again, the lesson is you can call them a manager. You can write in the job description that they have managerial responsibilities. They're supposed to be doing budgeting and planning and staffing and everything else. But if on the ground, in reality, week after week, they are opening and closing cash registers or operating cash registers, their primary duty is not going to be found to be managerial. Settlement here was $8.3 million for those employees. Okay, so there was a development in the news last week or 2 weeks ago which led to some question, is this even going to happen? Are these new rules going to take effect? The answer is yes, they're going to take effect, most likely. There is a lawsuit pending. Nobody thinks it's very likely to succeed, but Nevada and 20 other states have filed a lawsuit challenging the constitutionality of the new regulations, the new rule, arguing they have exceeded the authority of the agency and Congress. I mention it just because you may hear about it, but I would not put any stock in the likelihood that these regulations are going to be derailed. The planning should be premised on the assumption that December 1st, the new rules are going to go into effect. Okay, so we've reached the part of the program where we're happy to address questions that you have. Again, feel free to post them. I'm going to see them. Your fellow attendees will not. And I will do my best to respond to them in the remaining time that we have. Okay. Let's see. So I'm just going to look at a couple of these questions, see which have the greatest applicability, and see if I can answer some of them first. This is a common question, which is you've got an employee who is doing coaching or extracurricular work after school, and are those hours considered in counting the number of hours worked in a week? The question says, even if these hours are not required by the employer. So the first thing to emphasize about this is hours that are being worked, whether or not you require them, if you're aware of them, need to be counted. and that applies to off-the-clock work as well as extracurricular work or other work. This question comes up about extracurricular or coaching work a lot, and the rules are this. The question is, first, whether the work is regular or sporadic, right? So somebody who works for you, teacher or a paraprofessional, and occasionally helps out at an after-school game or special event for a club, unlikely that that's going to be required to be counted. On the other hand, if the work is regular and it is, so they're coaching a team or they're relating they are advising a club every week, that's not going to be considered occasional or sporadic. It also turns on whether the work is related or unrelated to their main work. So the question, as the Department of Labor puts it, is whether these are occasional or sporadic assignments that are not within the same general occupational category as the employee's regular work. So in short, if you've got somebody who you know is coaching or advising a club afterwards and they are non-exempt, meaning eligible for overtime, you are most likely going to need to count those hours as part of their hours that they're working in a week. We have a question about whether the PowerPoint presentation will be shared. Yes, we're going to post not only the slides, but the recording of this morning's presentation on the Krokidas and Bluestein website, which is www.kb-law.com. The question, how do you punish? Do you want to punish overachievers who arrive early and leave late, although they're not required to do that? This is a landmine here, and this is a very good question, right? You've got people who are working more than required. They may be your star employees. You may be delighted that they are doing this extra work. If, however, they fall into the category of non-exempt, that they do not meet one of the exemptions that we've talked about, and even though you have not asked them to come in early or to work after hours, you're aware of it, or you should be aware of it. The archaic terminology from the 1940s from the Supreme Court case was whether you suffer or permit the work to be done. You as the employer are benefiting from the work. It needs to be counted. It needs to be paid. So you may decide this is somebody you want to pay overtime to because they're a valuable, they're providing a valuable addition. You might want to regulate it. You might want to limit it and say, delighted that you're doing this work, but we need to track it because we want to be sure you get paid for all the work that you do. So please check in with a supervisor beforehand. In many instances, employers say to employees, we know emergencies come up. We're delighted that you're able to pitch in when things happen. We want you to be able to do that. We just want to know about it so we're sure that you are paid for it. So let us know, get permission in advance if it's an emergency, notify your supervisor immediately that it has happened, and that will give you as the managers the ability to assess whether this is in fact being properly accounted for and whether to, as I say, address it as a disciplinary matter. If somebody is not following the rule about prior approval or prompt notice of emergencies, you may write them up, give them a warning, and if it doesn't improve, go through the progressive discipline process as you would with any other rule violation. So a question come in says, do all the folks that make between $51,000 and $134,000 need to supervise 2 people? The answer is no. Well, I'm sorry, not over 134 for the highly compensated. The answer is no. Question, let's see, says between the 51,000 and the 134 need to supervise 2 employees. So the answer is not all. One of the 2 categories does require it, right? So the executive, to qualify for the executive exemption, you have to supervise 2 or more employees. However, professionals, there's no requirement of supervision, and the same with the administrative exemption. So each exemption has different tests. They've been identified, they've been, as I say, fleshed out through case law regulations and opinion letters from the Department of Labor. So you have to look at them separately. Computer employee, somebody asked about, that may in fact have relevance. We can give you the information on that. It's again, it relates to the technical level. It's not just somebody entering data, but it's a returns on their training, job requirements, as well as the level of work that they're doing. But there is a separate exemption for employees working with computers, software, and that sort of thing. Let's see. Someone asked about the school receptionist. Depends on the duties. Receptionist is typically not going to meet these exemptions. If they have other duties that qualify as them for the administrative exemption, it's possible, but receptionists typically not. A couple of questions about tutors and others who are not teachers. This is a hotly contested area. We would start with what the job requirements are, what the training requirements are, and the educational requirements. What are they doing? Are they exercising independent judgment? Are they in fact professionals and require this specialized training that we talked about to and would possibly fall into the professional exemption? They're not, though, teachers, so that automatic exemption for teachers does not extend to tutors. They would have to be analyzed as any other paraprofessional, whether it's a classroom aide or somebody else. Somebody asked back to coaching. Isn't coaching covered under the teacher exemption? That's a good point. A coach who is the coach for a team may well fall within the teacher exemption. The difficulty comes out where you have somebody who is assistant coach or helping out with a club or is not engaged in instructional activities, but is helping on an informal basis. Again, you'd have to look at the specific facts. Let's see. How are we doing? Got time maybe for one more question. Let's let me look at what we have here. So this last question says, if an employee works after hours, for example, after regular school hours for a special event, is that automatically overtime? Or is it only overtime if they have worked more than 40 hours? Very good question. The answer is only if it's more than 40 hours. So an employee who stays after for whatever reason, if those hours do not put them over 40, there is no need to pay them at the overtime rate. But keep in mind, if this is an employee who is paid on an hourly basis, they need to be paid at the base pay, their hourly rate for all work performed, whether it's before or after school, during a meal break, or from home. So a lot of these questions relate to principles of overtime law and wage and hour law more generally, right, about what's considered time worked, when does it have to be paid. And these are issues which come up regularly. We're happy to discuss them with you at any point. Questions, quick question or otherwise, feel free to contact us. We also will be sharing information regarding some of these issues via what we call client alerts that we put out periodically. and will be shared with all of you who have signed up for today's webinar. Finally, I'll note that we have other webinars scheduled. You'll be invited to those as well on wage and hour, as well as education-related issues. I want to thank you for participating this morning. Questions have been terrific. Hope that we've been able to provide some practical guidance. And again, always happy to answer questions about individual circumstances if you have them. Thank you again. Have a great day.